Yeah, so welcome back to Healthcare Law and Ethics. So just before the Christmas, we were discussing autonomy, consent, and informed consent. And we made the point that autonomy is a foundational concept in this particular area of the law, as well as medical ethics. And we noted that it underlies the very idea that individuals are entitled to make decisions concerning their own lives and their own bodies. And we even went to the extent of looking at the etymology or the origin of the word autonomy from the Greek language. And we said that if we look at this etymology, the autos and the nomos, that means a self-rule or self-law, self-governance. And that actually applies to the patient as someone who has to make the ultimate decision concerning what should be done to his or her body. And we attempted to explore the philosophical underpinning or the basis for autonomy. And we cited Immanuel Kant's categorical imperative. The fact that human beings should be seen as an end in themselves, not as a means to an end, and that is a very important philosophical justification for autonomy. And we also look at the other strand of philosophical justification for autonomy. We look at the John Stuart Mill's liberal theory, the famous no harm principle. So the harm principle simply to say that individuals have the liberty to make choices so long as they do not harm others. And we said that in our everyday engagement, we have the famous saying that your freedom or liberty ends at where another person begins, at another person's nose. That is to say that in Mill's libertarian thinking, whatever is not causing harm to another person is permissible. And that is another way of saying that the individual, so long as whatever is taking place in the clinical scenario or setting is very much about the individual at the center of it. And for that matter, he or she should be the person to make the requisite decision or give the requisite approval as whether something should be done or not to be done. And we said that beyond this interesting philosophical rendition of the concept of autonomy, it has also been reflected variously in the numerous human rights enshrined in our Constitution, particularly Chapter 5 of the 1992 Constitution. So we mentioned the fact that respect for human dignity, Article 15, personal liberty, Article 14, privacy rights under Article 18, and protection of life under Article 13. Directly and indirectly advances the value or the concept of autonomy. So in that regard, we noted that autonomy has been given a constitutional pedestal or conditional status, as it were. Then we also talk about paternalism. And we said that paternalism, of course, will appear to be the greatest enemy of autonomy, in the sense that it refers to the idea of permitting interference with an individual's autonomy for the purpose of promoting the individual's welfare or preventing harm to that individual. So as you can see, that is a very counterfactual or like a counter argument against autonomy as it were. But we also noted that in the medical context, if we wanted to go back to even the Hippocratic oaths and so many other ethical uh, levels of paternalism, we noted that is based upon the supposition or the presupposition that the clinician or the healthcare professional knows better, and is also based upon the idea of beneficence, the idea that the healthcare professional, the clinician, will always do what is good or what is in the interest of the patient, and that provide justification for paternalism, despite the fact that on another consideration, it is antithesis, or it is a quite opposite of autonomy. We talk about two aspects of paternalism. We talk about soft paternalism and hard paternalism. And with respect to soft paternalism, we did make the fact that where interference is very much encouraged, so long as the patient lacks capacity, particularly so an unconscious patient or a patient who is unable to make an autonomous decision, then in that case, soft paternalism is encouraged. Then we also talk about the hard paternalism. That is where you override the wishes of the competent patient. And generally speaking, such a ruthless, overriding or interference with the patient wishes is seen as inappropriate or illegitimate, except in very narrow or limited circumstances permitted by the law. We mentioned the public health emergencies as an exceptional case where hard paternalism may be tolerated. And then we move on to discuss consent. And with respect to consent to treatment or any medical procedure, we made the point that consent becomes the legal mechanism through which autonomy is protected in healthcare. So, therefore, we noted that medical treatment or procedure without consent is unlawful unless there is a recognized exception. So, in law of tort, for example, we mention battery, trespass with a person, where you make unpermitted contact with another person. You are considered to have defied. You are considered to have defied or violated the bodily integrity of that particular person. So that is why consent is very important. And so we mentioned the case of Sklendorf against against the Society of a New York hospital, a very early 20th century case, and we noted that Justice Cardozo gave a very famous statement regarding the necessity for consent, particularly so when you are dealing with an adult.
Yeah. But my lord,
Yes.
please, are you showing your screen? Because I cannot see it. I don't know if I'm the only one.
No, I'm not showing screen. I'm not showing screen. Okay. Yeah, when I'm showing screen, you know. Yeah, I'm recapping what we did. So
Yeah.
good. Yeah, so we mentioned this is Cardozo's famous statement in the Sprondorf against Society of New York, and where he made a statement that, quote, every human being of adult years and sound mind has a right to determine what shall be done with his own body. And a surgeon who performs an operation without his patient consent commits an assault. This statement goes back to the case decided in 1914. And that dictum is an apt description of what we are talking about as a consent, and where it is lacking, the implication for the validity of what you did or did not do for the patient. So we also, all this I'm talking about, discussed them already. So I'm just because of the holiday excitement, it might have disappeared a little bit. So I'm just trying to recapitulate. Yeah, we also talk about informed consent as distinguished from consent. And for informed consent, we made the point that it requires three basic things: that the patient must have capacity, then the decision should be voluntary, and the fact that the patient shall be given adequate information in a comprehensible form before he or she gave the consent. And then we sought to explain what capacity is. And with respect to capacity, I think we made the point that capacity is not yeah, we made the point that capacity is not a global or a status-based concept or idea, but by capacity, we are talking about something which is functional, that is decision specific and time specific. In other words, we are not talking about general capacity. We are talking about context or situational specific capacity. So therefore, you may lack capacity for one decision, but possess it for another. Or you may lack capacity for the time being, and then you regain it later. So the legal test or the criteria for making a determination whether a person has a capacity or not is to find out whether the individual can understand the relevant information. Can the individual understand the relevant information? Can the individual retain that information? Can the person use or weigh the information as part of the decision-making process? And then can the person communicate a decision? So all these factors or indices are important in trying to make a determination as whether a person has capacity to express consent, as it were. Of course, those who have learned law, capacity is a very familiar concept. But when we are talking about medical procedure or treatment, we are looking at it in a very specific sense. And not just talking about capacity to contract, let's say, in general, as it were. So therefore, we mentioned the case of RC adult refusal of treatment. And let me say a few words about why sometimes we use letters, alphabet to designate cases. Under English law, when you are dealing with minors and also persons that lack capacity, who are protected by the court, you need to withhold the identity. And that is why letters are used. So here, as an adult, all right, but because the matter involved, whether is mentally challenged in terms of having capacity and so on, we use an alphabet to designate him or her. And that is why here the patient was said to have a chronic paranoid schizophrenia and had refused a life-saving amputation. And there has been no diagnosis that that was actually needed. And when he refused, the court examined the evidence with respect to the parameters. The court examined the evidence with respect to the parameters that I have given as to whether the person can understand the relevant information, retain that information, use or weigh it as part of the decision-making process, and communicate decision. And the court was satisfied that the patient in question actually had capacity, and if he or she has actually communicated a decision that he does not want to submit to the crucial amputation or the life-saving amputation procedure, so be it. So in the court's view, this patient understood the nature of the treatment, the risks of refusing it, and the consequences of his decision. So the mere fact that a person has a mental illness does not automatically negate that person's capacity. In any case, if you look at the Mental Health Act, as you recall from your mental health course, everyone is presumed to be corpus mentis, to have a sound mind. And before a person will be declared as lacking that, procedure which involve both medical and legal determination will be made before a pronouncement is made. And that is why it's not enough. Just you think that a tag of mental illness is put on a person to automatically jump to conclusion that that person doesn't have capacity. It is an evaluative process which the court will have to engage in, weigh all the requisite factors, and then make the appropriate determination or calibration as whether the person has capacity or does not have no capacity. Similarly, in Ray MB, a pregnant woman, had extreme fear of needles. Of course, I don't know how many of you have. Well, until probably I grew, I was very much afraid of needles, and I didn't like injection. But now I've come to terms with it. I'm sure some of you, even some medical doctors and nurses, are very much afraid of needles. Is that not the case, Rebecca?
That is true.
Yes, you see, good.
Okay. Yeah,
You've been the exception.
No, there are some health workers that if you want to give them a simple iron injection now,
yes,
the whole facility will come to a halt.
Yes,
it's very true.
Yes. Yeah, but right now, with the going to lab, especially when they are going to prick your finger or to get blood. So we become used to it over time. Yeah. So this woman had such a phobia, and it interfered with her ability to consent to cesarean session. So eventually, when the matter traveled all the way to the English Court of Appeal, the court made the holding that temporary factors such as panic or fear may undermine capacity, but only where they prevent the patient from using or weighing the relevant information. So what it means is that the court does not endorse the assumption or just jumping to conclusion that somebody lacks capacity because of maybe a certain diagnosis or a certain emotional distress. No. So the court will engage in actual evaluative exercise. And that is why we say that is a functional capacity we are talking about. I think we also mentioned the Mental Health Act. And the Mental Health Act we cited at in session 97. Because we are learning mental health as a model on its own, I presume that we are all experts on the full gamut of the provisions of the Mental Health Act 2012 Act 846. So I'll not belabor the point, just to make a very tangential reference to it for our present purposes. So if we look at the definition or the interpretational section, section 97, capacity is, for example, defined as the ability to understand, retain, and use information to make a decision and to communicate that decision. And as I told you, capacity is presumed unless it's otherwise proven. That is to say that there is a rebuttable presumption. When lawyers or in law, we say that something is rebuttable presumption, what it simply means is that the court gives the benefit of the doubt, or the law gives the benefit of the doubt that, yes, you have capacity. However, if evidence can be adduced on preponderance of probabilities or balance of probabilities to convince the court that, as a matter of fact, you do not have capacity in terms of the criteria or the parameters that we'll be talking about, then that presumption will have effectively been rebutted or displaced. And if you look at it, you can see some alignment or some congruence, agreement between the English common law position reflected in Re C and Re Ambi, we've considered, and our own Act 846, as the case may be. Again, consent must be given freely. So therefore, if consent was obtained through coercion, pressure, or undue influence, such a consent will not have been given in a manner in which it can be said to be autonomous, to be free, unhindered. And for that matter, it will be considered as being invalid. It will not rise up to the threshold which the law expects to be attained before a consent is considered as a valid consent. So therefore, in the case of RETI, adult refusal of treatment, a pregnant woman initially consented to a blood transfusion, but later refused to allow the blood transfusion process to be done. And this U-turn decision by the patient was after she had been influenced by her mother who subscribe to the Jehovah's Witnesses faith, JW. And the question was whether her consent, the refusal of her consent to the blood transfusion, whether it was a genuine, valid consent or same was actuated by maybe initiating factor like undue influence, coercion, or pressure. And the court welcomed the view that yes, a competent adult may refuse treatment for any reason, including religious beliefs, such as maybe being the Jehovah's Witness and so on. But crucially, the refusal must be genuinely voluntary. So if there was no coercion, you've just been told something, and you yourself, yes, you have remembered that, okay, if I subscribe to this system of faith and so on, then I shouldn't do this or I shouldn't do that. That is a free decision which you have made. But where there's a undue influence, like maybe like instead, you try to, oh, why will you do this? You are a witness. You are a Muslim. You are a Catholic. You are this. You are Methodist. Why will you do this? This is, so assuming you bombard the patient with information in a manner which appears to be, putting some fear or some negative influence on the patient, then the consent or the refusal of the consent or the giving of it will not be considered as a valid one. So that is a point we are being reminded of.
No, please,
For that matter, just a minute, and for that matter, if you read the, go ahead. Go ahead.
Okay, so I have okay, let me put it this way. Back in a facility where I worked, we had two different cases of this blood transfusion issue. One in the case of an adult and the other one in a child. The adult one, we lost the woman, a twin mother. She died and left the twins because of refusal of blood transfusion. She belonged to a church that they don't, not Jehovah's Witness, one other church. And so they insisted that she was not taking the blood, the church members, elders, and everything. And so they didn't. The family members refused. And so at that moment, she was not in a very good state to have made a decision for herself. So the mother, family members, because they all belong to the church, they did that and we lost the woman. Then in another case at the pediatric ward, that one, it was the grandmother of the child. The grandmother belonged to that church, but the mother doesn't belong to the church. But the grandmother was insisting that no, the mother should not allow the child be transfused. And so we managed to somehow get them off the scene, spoke with the mother. At some point, you realize that she was giving us consent for us to go ahead and take care of the child. So we had to let the grandmother out of the scene, got the child into the theater, transfused, and hours later, the child was very okay, healthy. Few days later, was discharged. And then the grandmother came there jubilating all around that she had won that because she insisted that the blood should not be transfused. You see, she didn't take the blood, but Nigeria Jininkwa. But she told the mother to be silent about it and all that. And so I'm now, I was just I was a student nurse, or I just completed school by then. But so the doctors and my in charges took all these decisions, and he went through. So I'm thinking about what you are telling us now. In the case of the adult, who at that moment couldn't make decision for herself, but others took the decision and we lost her. And then the child that the grandmother had wanted us not to transfuse, which probably we could have lost him also, but for the intervention of the team, together with their mother, we drove the grandmother away and then we transfused the child in theater. The child got better. Would there have been any lawsuits? And then which form would he have taken? Who would have won and all that? Just thinking aloud.
All right. Yeah, so that's an interesting scenario you had. So the first one, strip of all the questions, basically saying that the patient was not in a situation, or to use technical language, did not have capacity to have consented or refused consent to the blood transfusion, but the church members present actually refused the consent. Is that the case?
Yes.
Good. So, with respect to that scenario, if a person does not have capacity, in some jurisdiction, there's what they call the advance directive. Advance directive where the person has given sometimes what they call the lasting enduring power of attorney to another person, that if I should be in a position that I cannot freely make an informed decision concerning my welfare, healthcare, and all that, then please do that on my behalf. Or he or she might have given certain directive that under no circumstance. So just like some people, for example, carry I'm a Jehovah's Witness in their wallet or in their purse. Yes. So an argument could legitimately be made that in absence of any foul play, as maybe the person not actually having taken that particular, or not having actually put that in the purse, and is being falsely attributed to him or her, an argument could be made that that is some kind of a legitimate advance directive as to whether the person should be transfused or not. So that one is there. But in absence of all those things, and having regard to the gray area we have in our jurisdiction, we must have regard to the Cause Act. Of the Court Act, for example, if you look at the Court Act, in terms of normal adults, you look at Section 19, for example, and Section 19 of the Court Act, I just quote it for you. Just listen. In addition to any jurisdiction conferred by any enactment, the High Court shall have power, subject to provision of any other enactment, A, on application by any person, and after hearing any objection to the application, to appoint any person as a guardian or as a joint guardian for a person of unsound mind, or to direct the person of unsound mind to be delivered into the care of a responsible authority or relative, where the court is satisfied that such course is desirable to ensure the welfare of the person of unsound mind. B, to vary or rescind for good cause an appointment made under paragraph A, and to attach such condition to an appointment as may appear desirable. C, to make such orders and give such directions as may appear necessary or desirable to secure the maintenance, safety, and welfare of a person of unsound mind, the efficient administration, disposition and management of any of his property or affairs, and for such purposes ancillary to them. And D, to make such orders as appear necessary or desirable to secure the carrying out of any contract entered into by a person of unsound mind, or the conduct of any legal proceedings in his name or on his behalf. So in terms of Section 19 of the Courts Act, 1993 at 459, as amended, the High Court has a jurisdiction when the court's power is triggered or invoked by any person, and the emphasis is any person. So it can be the hospital, for example, and this is where I want to challenge hospitals, health facilities in Ghana to rise to the occasion, just as we have in England and Wales and other jurisdictions, where hospitals on their own will even go to court to seek declaration as whether certain procedures about to be embarked upon or procedures will be discontinued, whether, for example, it will violate the law or not. So, like the scenario that our friend, the doctor, has narrated, if the hospital, for example, had made ex parte application, so to speak, you go to court, you tell the court that having regard to these exigencies, time is of the essence. And for that matter, you cannot be on notice. So if the court should miss a certain quick determinations and orders, that will have been done. And we know the outcome. And the second scenario, where the patient, the relatives were there and the relatives had to go out, and in their absence, you transfuse.
Yeah, it's actually a child. So the mother is not a believer of that, whatever. It's a grandmother.
The grandmother, good. So there was the mother present.
Yes, so we had to get the mother.
So if the mother is present,
engage her.
Yes, and the mother consented that the transmission will take place.
Yes.
Yeah, then
but
that
not with the not in agreement with the grandmother. So that procedure, the grandmother had to be somewhere else.
No, but
she wouldn't have agreed.
Absolutely, but the grandmother was inconsequential. I mean, she doesn't really add to what is required for validity, because under the Children's Act, is the parent. Yes, who will have
in the area where I am talking about, and then like some of these things that the hospitals are even supposed to have some rights to seek whatever for on behalf of the clients and all that. Most of the facilities, I can say we barely do these things. But in the space where I am talking about this, the grandmother had some total control. And if we did not, the team did not manage the situation well, she would have actually had her way.
Right. Yeah, so for me, the takeaway, yes, proceed.
Good evening.
Yeah, good evening.
Good evening.
Yes.
I guess I wanted to comment on the second issue.
Okay.
The second scenario she narrated, like you just pointed out.
Right.
At that point, it's about who has the authority or capacity to make that decision. And one, irrespective of the noise the grandmother will make, that power lied in the hands of the mother and the children, as you say. So that if the hospital had the necessary protocols, and as she said, they briefed the mother well, and the mother even gave consent to it, well documented, the grandmother, if it even turned back, could not have sued. The grandmother could not have sued because she would not have capacity to sue. At that particular time was vested by the children. My second thought about the whole thing is about the first scenario. And I want to ask this question in relation to what she narrated. When we preach about preservation of life, when doctors take oath to preserve life, save life at the peril of even their lives, I mean, medical practitioners take that oath to do all those things. And we have these religious beliefs where at times it is clearly evident that the one proclaiming to believe in that religious culture does not even understand it and the consequences that it brings to him in refusing to receive that care. What is the role of the law there? Where does it shift the balance? Does it empower the medical professional? Because at that time, they have the professional know-how to save that life. Where does the balance tilt to?
If I understand you, where there's a clash between religious and religious and cultural values on one hand and the law. What is the position of the law? Is that the question?
Yes, my lord.
Okay, good. Now to start with, as it's often said, the law is the law. In other words, once we have like a statutory provision, if you have a statutory provision, and for that matter, constitutional provision, don't forget when it comes to children, it's not just a matter of the Children's Act or even like the Courts Act. The Constitution itself has actually, indicated that they should not be deprived of medical treatment on religious or some other grounds. So it's a constitutional matter. That is one. And two, in other scenarios, like we have like competent adults who have capacity, and just as if you are sick, you decide to go and seek medical help, isn't it? If you are sick and you don't go to hospital, nobody will do anything to you, except where you are dependent. And then the person who is your guardian or who is supposed to be your carer or provider fails or refuses to seek life-saving medical intervention for you. And let's say that you die or something catastrophic occurs. There could be a case of manslaughter and so on because you were a dependent. But where you are your own person, you do not depend upon like anybody to be looking after you, and you have to make a decision whether to go and seek a medical intervention or not. And you don't do, and you die, you have chosen to allow your condition to lead to your death. So in the same vein, if you go to hospital, we are going to do a procedure on you. If you are clearly compos mentis, you have sound mind, and we don't have any vitiating factor of maybe coercion, on the influence, or the rest being visited upon you, and you have clearly, unambiguously, unequivocally indicated your preference that you do not want a particular procedure, so be it. For example, when it comes to surgery, some surgery will require blood transfusion. Now, I know we have alternative products to blood. And about 4 years ago, I had a colleague working with me in the Faculty of Law, in the university, where the mother was going to have orthopedic surgery. And the person is a Jehovah's Witness. So their elders had to follow the situation and make the necessary arrangement to ensure that you have enough, they have a certain product which is supposed to be an alternative to blood. It is said that it can perform the same function as like natural blood. So if you don't want transfusion, So they did all the necessary arrangement. And then the patient said that she didn't want transfusion, despite the fact that the procedure will require, and that she is confident that this alternative product can perform the same role. They did the procedure, and thank God she survived. She was successful. But assuming it had not been successful, you used the product and then she died or something, that would have been her own decision. Yes.
So my lord.
Sorry?
My lord, a follow-up.
Yes.
A follow-up on your last submission.
Yeah.
Can the medical facility, when they know that this procedure, you require blood transfusion, and in fact, maybe not let's say 1 pint or 2, but you require because of the nature of the transfusion, and you say that you don't want transfusion, can the medical facility refuse to do that procedure?
Because you are refusing the blood transfusion, and then the medical facility say that, well, if you're refusing the blood then we cannot. Now, it will depend. If if the medical procedure, if the medical facility say that, well, we are aware that there are medical products which are substitute for blood transfusion, but unfortunately we do not have that. And because we do not have that, if you do not want natural blood transfusion, then we are sorry, we cannot guarantee the safety of the procedure, so we cannot go ahead. Yes, that can be the position of the facility.
Okay.
Thank you.
Very well.
Okay, so no, good evening.
Good evening.
No, good evening.
Good evening, sir.
A long time.
Oh, sorry.
Yes. Yes, my questions are now numerous.
All right.
But my first question is a clarity.
All right.
I want to be clear whether the autonomy of a minor lies in the hands of the state.
Whether the autonomy of a minor lies in the hands of the state. Okay,
yes.
Good. When you look at the Children's Act, there's what we call the paramount principle. That is the best interests of the child, what we call the welfare principle. That in any determination, the best interest of the child is what is paramount. And in making what constitutes the best interest of the child, ultimately, the court will have to do the evaluation and make a judicial determination or adjudication that X, Y, Z will be in the best interest of the child or not. And then the question is, who should the court consult? Whose evidence should the court take into consideration? So many, including the parents or people looking after, sometimes even like social welfare officers can be commissioned to make a certain technical assessment and so on. And we're going to discuss the Gele case as an interesting case where in English law, the court will even say that depending upon the level of maturity of the child at the center of controversy, if the particular person demonstrates the requisite maturity of appreciation of matters requiring some consent or otherwise, if the person demonstrates that he or she understands the complexities and the nuances, the court is supposed to give important weight to what the child, otherwise a minor, is saying. Yeah, so that is how it is. Yes, But if you look at the Children's Act, for example, so we look at the Courts Act, Section 18, it also gives like a special jurisdiction to the High Court over these matters. And of course, the Children's Act will open it up even to the the family tribunal and so on. But ultimately, where there's a dispute, it is a court which will make like the final adjudication as to what is in the best interest of the child.
All right. My second question is about the case of the client who is schizophrenia.
Okay.
Where the court ruled that he has a capacity to make an informed decision.
Okay.
Yes. If you look at the condition very well, it says that schizophrenia is a chronic brain disorder which disrupts a person's thinking, emotion, and behavior with classical signs and symptoms of hallucination. So based on that, did the court still think that the patient have a sound mind to make that informed decision?
Okay, good. You see, from the medical...
Stressing from the word chronic.
Yes, but then from what you said, you talk about the hallucinations and so on, and all those things suggest that there may be some, what they call the lucid interval, or there may be time, some occasions that there may not be attack or something, or seizure, as it were. So, assuming the patient is in that state, then momentarily, that patient has some level of a capacity.
All right.
Yeah.
Thank you.
Yeah, so you've done mental health law, so I don't want to belabor this point on voluntariness and undue influence. So please, we'll go back and look at the section 39 to 41 of Act 846 with respect to voluntary and involuntary treatments. Can anybody remind us in brief what the legal position is under the Mental Health Act, or what the law is with respect to voluntary mental treatment and then involuntary? Yes. Anybody? You studied this as a course on its own. Yes. Anybody? Are you not doing mental health law?
Okay.
Yeah, so tell me about it.
Please, with the voluntary treatment of a mental health patient or client, it says that the mental health or a person with a mental health disorder can go for treatment, whether with or without a referral to a mental health facility. So that would be a voluntary treatment. The client going there himself.
Okay.
Thank you.
Yeah, so as yes.
So there are some instances that the patient may not know, or the client may not know, that it requires the services of the mental health. Significant relations, friends, and others can suggest that. So that will become more of an involuntary kind of treatment, such that they want to, as it were, be able to control chances of causing any harm or injury to the people around him or her. Thank you.
Very well. Yeah, so please look at those provisions. Now,
but look,
yes,
I wanted to. So with the minor, I know
yes,
there is a group of minors that we call them emancipated minors. Now, these emancipated minors, we had more of them somewhere in South Africa and Rwanda. In Rwanda, following the genocide. And then in South Africa, when HIV and AIDS was at its peak and claimed minimal lives within families. So you would have realized that a child, 10 years, 12 years, takes responsibility of the household. And so the fellow will have to fend for him or herself and those that are, as it were, behind him. That is the younger siblings. So in that case, can the child take decisions, especially when it comes to medical decisions? And I'm looking at resource-constrained settings like Africa, where we have fine laws, but we don't have that buffer that is able to cater for them. Because when you go to our hospitals and there are issues, the social welfare is not functioning because there is no voted funds to cater for these things. The hospitals are also handicapped. They are not able to manage some of these things. So your best bet is to go for what you can afford, even though there may be other alternatives, but the cost may be a hindrance to you choosing those ones. So can the emancipated minor make a decision that will stand? And the next one has to do with the operations of the health facilities and the community. So as a practitioner, I know there is one thing that is very important. We need to, as it were, kind of be culturally or religious competent. By so doing, you don't just wash away the beliefs of the people. Because when you do that, you will not be able to survive in that community. So what we do is that we try to, as it were, create a certain room for them, because I work in a remote area, to create a certain room for them so that they will buy into the, if you like, the allopathic medicine, so that you will now be able to get their attention and, as it were, preach the practices that are good, so that we will continue with those ones. And the practices that we feel they are not good for their health, then we are able to do that. When you do that, you see that you are able to win them to your side and they believe what you do. But if you go and wash away all their beliefs based on law and all those kind of things, I don't think you will last there. Those who tried it, the communities were up in arms, they will beat them. And I'm sure the law is there, but the law is dormant. And all these people were injured. The best they can do is to compensate you with something small, and you are forgotten. Maybe you are maimed and all those kind of things. So I think in the best interest as practitioners, sometimes we can try to find other alternatives so that we have their buy-in, then we are able to press that rather than testing the law all the time. Thank you.
Right, thank you. Yeah, so your contribution duly noted, but the concept of emancipated minors is not a taxonomy, or is not the which is known to our law. You look at our Children's Act, you look at the Court Act and the Constitution. That notwithstanding, the substance of that doctrine, emancipated minors or children, as pertains in some comparative jurisdiction, is reflected significantly in our own law. Yeah, so as you rightly said, the emancipated minor or child are those who have not attained the age of majority. And under the Convention on the Rights of the Child, the age of majority is 18 and above. So below 18 is a minor. And that age is more or less followed in almost every jurisdiction. So not until a person has attained that age of majority, he or she does not have the capacity in law to make autonomous decisions and choices and so on. But in jurisdiction where this emancipated minor exists, some minors who are subjects of abuse, exploitation, and other unfortunate circumstances may be accorded that status, so that despite the fact that they have not attained the strictly legally prescribed or calibrated age of majority, which is 18, such minors are indulged by the law to behave as if they had attained the age of minority. Now, if you look at our own Children's Act, for example, let's say if you look at the section 13, we have what you call the protection from torture and degrading treatment, for example. So, and the provision that no person shall force a child to be betrothed, to be subject of a dowry transaction, or to be married, minimum age of marriage, whatever kind shall be 18. So assuming you have, let's say that a child, without meaning any offense, especially in some communities where the religion is Islam, there used to be that observation that children are given in betrothal at a very early age. So let's assume that that is the case, and such a child is also subjected to certain exploitations, and the matter comes before the court. The courts will make determination for the child to be put under protection of the state. The social welfare, as we said, will come in. And then, if we look at the Courts Act, section 18, because the High Court has general jurisdiction, in addition to whatever jurisdiction the Children's Act confer over infants, such a child, for example, could also come out for the court to give orders concerning whatever pertains to the child, including legal proceedings, properties, and so on. Yeah, so as I said, the concept is not immediately available or part of our law, but the substance of it is reflected variously. Yes. But the other point we need to note is that social welfare, Department of Social Welfare is very important, but those of you who be doing like the special paper, if one of you can take as an area of interest to try and investigate how much budgetary allocation is made to the social welfare department, and for matters relating to these things we are talking about, you can decide to look maybe the last 20 years or the last 10 years. You tell like the budgetary statements, and then the appropriation acts passed by Parliament to try and isolate monies, earmark, and release to social welfare departments. And then you try to find out whether the state is resourcing the department to be able to live up to its expectation of some of these matters that we are discussing. That would be an interesting study. Yeah, so the other point to note is that there is a direct link between information disclosure as far as informed consent is concerned. So for consent to be informed, the patient must be given sufficient information about the nature and purpose of the proposed treatments, the material risks and side effects, reasonable alternatives, including maybe no treatment, and the likely consequences of refusal. I remember very well the case of Montgomery against Lancashire, where the UK Supreme Court gave a very helpful teaching that you have to give information which will enable the patient weigh the options and make a very conscious decision to accept or to refuse. And that is important. Because if you have told me only about a diagnosis and you don't tell me that, okay, for this diagnosis, from the literature or from a medical practice, orthodox practice, so this, if you have this diagnosis, if nothing is done within 5 years, within 3 years, within this will be the consequence, this will be it. And then if something is to be done, there are 3 things which can be done, this or that, this or that. These are the implications. You need to lay all these things bare to the patient to enable the patient to make a choice, particularly so where the various options at stake may have their own attendant repercussions or implications. Some may be quite devastating, others may not. The patient needs to be told all that so that he or she will go in for that with suit his or her life purposes or goals, as it were. And I was giving you the example of men when it comes to prostate treatments. There are some options which are very effective, but then just as you succeed in solving the prostate problem, you're also going to have your ability to have conjugal activity compromised or terminated, probably for the rest of your life. And so the person will have to be told, do you want to have that and be able to live relatively longer, or you want to be able to have your regular conjugal activity and then you shorten your life? The patient will have to make like the choice, as it were. The same thing when it comes to fibroid treatment. The medical expert will tell us, in some case, we maybe have to remove your womb, in which case you'll be able to have your normal life and live your God-given lifespan. But then if we don't remove, and in that case, we'll not be able to have a child. And then if we also don't remove your womb, you can have a child, but there's a high risk that it can shorten your life, as it were. Doctors, is that not the case? Do you have an obs and gynae here? Yeah, so the patient should be, bottom line, the patient should be given all the requisite information, not in strictly technical sense, no, but in a reasonable language, which will enable he or she to be able to understand. And of course, that also has to go with saying that know your patient. Patients are not the same. So if you know your patient is very well educated, you can speak to the patient at a certain level. If the patient is uneducated, you also have to make sure that we come to the level which will make sense to him or her, as it were. So if you look at the section 97 of the Mental Health Act, it's also tried to, for the first time in our law, to try and statutorily provide informed consent. And you've made this over and over in your Mental Health Act, so we will not belabor the point. Now, if you look at the cases that the RIT that we'll be looking at, which all pertains to refusal, you see, as a matter of fact, when we are dealing with consent, the really sticking point is where you have a refusal. Refusal is what makes it critical. So most of the problem areas will be refusal. That is a patient refusing treatment or procedure. That is where it may become necessary for us to make an assessment as whether there was capacity, there was valid consent in terms of the refusal and so on. Now, what about where a person is seeking assistance to commit, let's say, suicide? If, of course, UK, for example, not until recently, just the last year, when they started a very strange procedure of trying to legalize assisted dying, you could not seek assistance to, for somebody to help you to die, as it were. And if you look at the cases like the rape treaty against the DPP, among other things, the court will say that because of criminal law position, causing unlawful harm or manslaughter and murder, the state, like state health facilities and so on, or anybody cannot be expected to provide assistance to another to commit, let's say, suicide, as it were. But then, as I said, as far as UK is concerned, this position is changing because of the new law which they are making, to enable assisted dying to be undertaken in strictly defined circumstances. I think that it is a bad law which should not come to Ghana under any circumstances. The reason being that, first and foremost, you are playing God, and quite apart from trying to play God, there's also slippery slope. The slippery slope argument, what they call the Pandora's box or the floodgate argument. As soon as and AY, your hand is up, correct? Is it by mistake?
No, please, my hand is up. This is Adeline.
Oh, Adeline, yes.
Yes, please. When we're talking about the consent, there was this case in 2023 that free hernia surgeries and a lady in her 40s. Okay. So after they had opened up in attempt to repair the hernia, they realized that it wasn't just limited to the Sister Mary Joseph nodule, but the of malignancy in the system. and the patient had already been open up and unstable. So then they had to reach out to the ONG team to come around, and then a total hysterectomy was performed. Woke up, they informed her, and what she said was she was grateful, even that she's not sure she would have been able to even pay for such a procedure separately. So I want to ask if it were in the condition that the patient had recovered and I was informed about this situation or the operations that had taken place, does the doctors have any stand to win a case, or the patient can take them on and win the case? Thank you.
Right. So if I understand you, that the patient had consented to a particular surgery or a surgery targeted at a particular problem, but then while the patient was opening up, it became necessary for some other things to be done, which the patient had previously not been told for he or she to consent to. Is that the case?
Yes, please. The patient presented with the Sister Mary Joseph nodule.
Okay. And then she was opening up and there were other things.
Yes, so they had to do a total hysterectomy, like take out the
womb and stuff. Okay, which he had previously not consented to.
Yeah, because the malignancy has advanced already and she had been opened. For her to be closed up, open again would have put her in danger.
Good. That is a very...
But she wasn't charged. She wasn't charged for the free surgery in the first place for the hernia before the ONG team invited to come and take up the hysterectomy process. So she wasn't charged for any of those. So she was grateful because she said she couldn't afford it. So I'm asking, what if it were the other way around, of the patient?
Right, not being happy with, right. Good. So to start with, it's not about payment or non-payment of money for the procedure, which will justify consent or lack thereof. Good. And secondly, coming to the specific or the scenario that we had, it also comes to what we are discussing now, the disclosure of information. How much patient? Yeah, the patient consented to a limited surgery, not complete hysterectomy or complete removal. But when the patient was opening up, based upon technical medical judgment, the situation was that it was absolutely necessary for everything to be removed, and you didn't want to close up and open, as you rightly said. Now, it will depend upon the diagnosis which the patient had been told and the options, the procedure. So it's very much, we cannot right away say that, assuming the patient was unhappy, as whether the facility would have been in the wrong or what the facility did was right. It will depend very much upon the information which was made available to the patient regarding the diagnosis, regarding the procedure, and probably the prognosis, as it were. So that if, and in any case, if you are doing a very thorough discussion with the patient, this particular extreme side of it, which is possible associated with such condition, will have been brought to the patient attention that, well, yes, what you have brought ordinarily is quite not dangerous, but then there's possibility that there might have been other advantage which we've not been able to reveal by just the normal diagnosis that you've done. But as we go in, if that is the case, And then in that case, if nothing is done, that could create adverse complications and so on. So if the patient has been told all this, the patient who has come to the hospital for treatment because the patient wants to avoid getting complications or avoid dying earlier than her time, will certainly have agreed. So that is it. And there's also a school of thought which says that we have what we call the implied extended consent, such as the scenario that we presented, that yes, the patient has consented to that limited surgery, but then because she has consented, she certainly wants a solution to that problem. So if she is opening up and there's an advanced development of that condition, which warrants total removal or hysterectomy, otherwise the patient will die or the patient will get in an extremely worse situation, which will undermine whatever benefit that she hoped to have had with respect to the limited surgery that she consented to. Then it's time to reason that such a patient will be implied to have also consented to the procedure that we did. So that is another school of thought. Adlan,
right.
does that go?
The patient was, yes, please. The patient was lacking the capacity, if I could see from what you are yet to speak on, because at that moment there was no way they could have consented.
No, not the. At the time that she came, the initial procedure, she had capacity, didn't she?
Yes, please.
Good.
Yes, please.
Good. So the surgery that she had consented to was just a limited one. But then when she was opening up, it was clear that the limited one that she had consented to was not enough because the condition had actually escalated. And that is why there's a school of thought which says that then the limited one she consented to could be taken as being an implied consent to do what you did.
Okay. All right, thank you.
So if you look at the public health cases like the Raybeck against the General Medical Council and so on, the court will remind us that the autonomy that we'll be talking about mainly promotes or protects the right to refuse treatment and not a right to demand particular treatment. And I think we all agree with that. So therefore, doctors do not have any legal obligation to provide treatment they consider clinically inappropriate or contrary to the patient's best interest. So your autonomy does not mean, your autonomy, is mainly protected when it comes to refusal of treatment, but not to demand particular treatment. Of course, that will have been put in perspective. And now, if you look at the Raybeck case, that was against is in the context of public health facility, like the NHS facilities and so on. So, but if you went to a private facility, private facility where health services are some kind of like a commodity, just like in a consumer can elect what to pay for and what not to pay for. Now, where you have that, in that case, the autonomy will not just be refusal, but will also be like what the patient wants. That is the other thing. But especially when it comes to this cosmetic surgery, that becomes very significant. For example, where a patient will say that we have in a certain condition, a patient will say that he thinks that his right hand is right hand, and for that matter, where the right hand is mistake. So please do a surgery, remove my right hand and bring it to the left, and take the left to the right. They have a certain medical, psychological conditions like that. But let's say that you, as a health expert, will say no, there's nothing wrong, or as it were. Or when it comes to this gender surgery, somebody will say that I want to remove my penis and make it into vagina, or remove my vagina and grow a penis and give me hormonal treatment, which will let me begin to feel like a woman or begin to feel like a man. So these are some of the challenges, and where we have a critical problem. But as we have seen from even our own Mental Health Act, in UK, cases like F against the West Berkshire Health Authority, the House of Law also reminds us that if you have incapacitated adult, that is adult who lacks capacity, you can treat that adult without or against his wishes, because his wishes cannot even be considered legitimate because the person lacks capacity, if the particular treatment is considered to be in that patient's best interest. So in that respect, the doctrine of necessity is considered as providing justification for such a medical intervention where consent cannot be obtained. And if there is any delay, that will be extremely harmful or devastating. As you can see, there are some situations where time is of the essence, and in that case, it may be legally permissible to treat the patient without any explicit consent. Yeah, so we've already made reference to the elaborate provisions of the Mental Health Act on involuntary treatment, emergency interventions, and also the guardianship type arrangement. So because you have learned this in Mental Health Act, I do not intend to belabor it. So whatever you are reading there applies mutatis mutandis to what we are talking about, with the necessary modification. Yes, the case I wanted us to talk about before we be finishing is the case of Gaelic, the West Norfolk and Wishbeck Area Health Authority. Particularly when you're looking at the issue of children's and then consent to medical treatment or procedure. So the Gaelic case, very interesting case, arose in the context of adolescent reproductive health, and the Department of Health and Social Security in the UK had issued a circular in the 80s, and the circular was supposed to speak to doctors or healthcare providers what they should do. Among other things, that doctors could provide contraceptive advice. I'm talking about this, after pill and those other medications supposed to prevent pregnancy or reverse pregnancy and so on. They could provide contraceptive advice and treatment to girls under the age of 16 without parental knowledge or consent, provided certain conditions were satisfied. Around that time, we have the problem of teenage pregnancy going on and so on. So it was necessary to do something about. And, when it comes to sexual life, is one thing about human beings which is quite mysterious and strange, in the sense that it's not an easy subject to open up about or to talk about. And it's also the same even when it comes to parents and children. So you may get a child, a daughter, who may not want to speak to even like the parents about her sexual experiences or development. But they still understand what is going on. So that was the background. So in this case, a woman called Mrs. Victoria Gillick, she had 5 daughters who were all under the age of 16. And she went to court seeking declaration against the health authority, making the point that the directive or the guidance issued was unlawful because it interfered with parental rights and encouraged unlawful sexual activity among teenagers. So she put out the argument that doctors who provided contraceptive advice or treatment to her daughters without her consent would be acting unlawfully, and further that such conduct will amount to an assault or battery, as her daughters lack the legal capacity to consent. Mind you, where consent is not given, as remember the case of Skrondorf against New York Society, then a battery will have been committed. So as you were saying that yes, if the person is below age and cannot give a consent, and you do that, then you've committed battery. And she also argued further that it will undermine her parental rights to control and guide her children's upbringing, including their moral and sexual decisions. The defendant, that is the facility and then the government department on health, contended on the contrary that doctors owe duties of confidentiality and care to patients, including minors. And some minors possess sufficient maturity and understanding to make informed decisions about medical treatment. So requiring parental consent in all cases will deter vulnerable adolescents from seeking medical advice with serious health consequences. So this case traveled through the lower courts and eventually came to the apex courts of UK, the House of Lords. And the legal issues before the House of Lords were that one, whether a child under the age of 16 is ever legally capable of consenting to medical treatment without parental consent. And 2, the nature and extent of parental rights in relation to a child's medical decision-making. 3, whether the Department of Health guidance permitting confidential contraceptive advice to minors was lawful. So these were the issues before the court. And the House of Lords, by a 4-1 decision, Lords Fraser, Lord Scarman, Lord Bridge, and Lord Templeman, all in the majority, as against Lord Brandon in the dissenting, dismissed Mrs. Gillick's appeal. That is, say that the court disagreed with the position canvassed by the woman. And the court held that a child under 16 years may lawfully consent to medical treatment if they have sufficient understanding and intelligence to understand fully what is approved, what is proposed. And this decision of the court brought about the familiar expression, what we call the Gaelic competence. So when you hear Gaelic competence in medical law literature or papers, it just refers to the idea that if you have a child, a minor, but if the minor demonstrates sufficient understanding and intelligence to understand what is proposed, then such a minor is Gaelic competent and you can deal with the minor with respect to legality of consent. The court held that parental rights are not absolute and diminish as the child acquires the capacity to make decisions independently. And consequently, the guidance issued by the Department of Health was lawful, provided doctors exercise professional judgment in assessing the child's maturity and understanding. So that is the decision in the Gaelic case. And with respect to the nature of parental rights, Lord Scarman provided a very interesting teaching or illumination, and he rejected the idea that parental rights are proprietary or absolute. In other words, parents do not have indefeasible or absolute right regarding matters, decision pertaining to their children. It's not absolute. And Lord Scarman would rather characterize parental right as fiduciary and functional, and exists primarily to safeguard the child's welfare. So he stated that parental rights exist for the benefit of the child and not the parent. And then parental rights diminish as the child's capacity and maturity increase. So our right to make decisions and control our children goes down as the child become more and more mature. So there's some kind of, if you want to render in mathematical annotation or language, there's some kind of what they call the inverse relation. So as the child advances in the maturity, then you are right, or as a parent, in terms of decision making and choices on the child, declines or goes down. So parental rights terminate when the child becomes capable of making their own decision. So that is very, yes. Yes.
Sorry for interruption. I would like to ask this.
Maybe let me finish this so that when I take your question, then we finish. Okay. Good. So Lord Scarman, on the other hand, stated a very profound proposition regarding capacity of minors, and this is how his lordship rendered himself. Quote, "The parental right yields to the child's right to make his own decisions when he reaches a sufficient understanding and intelligence to be capable of making up his own decision on the matter requiring decision." And as I said, it is this proposition which has been given the label Gaelic competence. So here is a functional test of capacity. It will vary from child to child. So some children will pass this test, in which case, despite the fact that they haven't attained the age of majority or they are below age, they will still be considered in law as having the ability to make a decision concerning their well-being. But if you look at our Children's Act, you will notice that Gaelic competence is also reflected, particularly when it comes to the welfare principle, that where the court makes a determination that the particular child, let's say, understand what is being considered, the child, that will have to be taken into account. So if you look at the Section 11 of the Children's Act, for example, quote, no person shall deprive a child capable of forming views the right to express an opinion, to be listened to, and to participate in decisions which affect his well-being. The opinion of the child shall be given due weight in accordance with the age and maturity of the child. So Section 11 of our Children's Act, in a sense, codifies or enacts the ratio dissidenda of Gaelic case. So the Gaelic competence has been given a statutory footing, because Section 11 is saying that if the child, for example, demonstrates the ability to demonstrate the maturity and the ability to express an opinion, then when it comes to matters pertaining to that child's well-being or welfare, that child will have to be listened to, and important weight will have to be given to the view expressed by the child in making determination of matters which affect his well-being or his interests or welfare, as it were. Yeah, so I think now I can take your question.
I wanted to know why a child of 16 years can be married.
But that's not what we are discussing.
Yeah. The Gaelic whatever. Because if at 16 years you can be tested and proven that you are capable of understanding some decisions and you can make decisions for yourself, it means if the child has sex at that age and is proving to the society that she is intentional and she understands, then it shouldn't be considered as rape then.
Oh, no. Okay, so your question is relating to defilement and then the rape. Okay.
Together with what Jacqueline asked, the marriage and everything, because they will say you have done child marriage, so the person involved will be arrested or whatever. But maybe at 16, the child understood whatever he or she was doing under the Gaelic competence.
Okay, you see, when it comes to marriage, it is a public policy thing. So for the sake of education, of the child, then society will prescribe an age. So what is the age of marriage under the law? What is the age of marriage under the law?
My lord, 16 years.
21.
Hey.
18 years.
All right. Yeah, as well, 21, that's too far. So some people cannot wait till 21, so 18 years, yeah. But some people have concern even about this defilement, because if we look at it, so if you have someone who is below the age of 16 having sexual intercourse with another person, does that person commit defilement? Anyway, we are not discussing criminal law and then criminology. So, but if you are interested in this discussion, later you can contact me and then we can have our own conversation. Good. So, from the Gaelic case, we distill the fact that capacity is decision specific, is fact sensitive, and independent of chronological age alone. So it's not just the age, which automatically will mean that you have capacity, especially when you are dealing with children. If you look at the Lord Fraser's opinion in the same Gaelic case, he issued practical guidelines, which we call the Fraser guidelines, just after his name, when it comes to how to manage contraceptive advice for minors. And he, Lord Fraser suggested that a daughter could proceed without parental consent, where, among other things, the minor understands the advice. The doctor cannot persuade the minor to involve parents. So the doctor will tell the minor that, yes, should I tell mommy or daddy? And if the doctor is unable to convince the minor to agree to allow the parents to come into the picture, then if the minor is likely to continue the sexual activity regardless, like she will continue to be engaging in those sexual activities. And then the minor's physical or mental health will suffer without advice or treatment. And the treatment is in the minor's best interest. The healthcare professional can go ahead and give the contraceptive advice without the involvement of the parents. So if you look at it, it's some kind of like a compromised approach. It's not just say right away that the parents are not important. No. You try to persuade the minor that, yes, allow daddy and mommy to come in, and we making a decision as whether we should give you contraceptive or we should give you this, planning treatment and so on. But where the minor has, rejected that, and you also look at the information you have gathered from the minor, that she will continue to be engaging in sexual activities and is going to be detrimental to her and so on and so forth, then you can go ahead and then give the treatment as it were. Yeah, so let's keep that in mind. And that is why I said that if you look at our law, it's, essentially comes to what the Gaelic is talking about, that if the minor has the ability or the maturity to make input into something relating to his or her well-being, then that should be it. Yeah, so I will take questions if any.
I think Jacqueline's question, I don't know if you were done explaining that to the age and the marriage, and at what point in time it becomes lawful or unlawful.
I think somebody came in. So at what age is lawful to allow the minor to engage in sex? Is that the case? Jacqueline?
Yes, and then
Jacqueline?
Yes, my lord.
Yes, so
Yeah.
are you worried about the age of marriage?
Yes. Yes.
Okay. So,
to know the age that someone can marry, and that if somebody is not up to 18 years and the person is engaging in sexual activity,
Yes, you have to be 18 before you can get into marriage. And of course, 16 years where you engage in sex with an adult, it doesn't, because the law says that you cannot give consent at that age. So it doesn't matter that you consented. That consent is not considered valid because of the age. And as I said, this is a public policy issue. A public policy issue in the sense that we want children to be able to get education. So if you look at the section 13 of the Children's Act, section 13.2 says that the minimum age of marriage of whatever kind shall be 18 years. So just the law, section 13 of the Children's Act, which I just stated, that in Ghana, not until you are 18 years, you cannot be given in marriage, as it were. And as I said, it's largely public policy. It's largely public policy, also consistent with the inspiration from the Convention on the Rights of the Child. And the idea is to enable children to get at least some education. So by 18 years, if for nothing at all, you have finished secondary education. So that is fine.
Doc, now they are not even marrying. They are mothers. They are giving birth. 14, 15.
My lord.
Yes.
My lord.
They are giving birth.
Please. They're 18 years. Is there no caveat? Because